Mike Demerges here with Professor Jack Breslin of Media Law at Iona College, and interesting stuff going on in the world of sports and media. JPP, Jason Pierre-Paul, defensive end for the New York Giants, is suing Adam Shefter of ESPN for posting the Sackmaster's medical records to millions of viewers and readers. JPP blew off his finger in a July 4th fireworks accident this summer. Let's get right to it, Jack. Is Shefter within his rights as a reporter to post the images because JPP is a public figure?
Okay, let's define the public figure first. It goes back to libel law. Is he someone who is thrust himself into the limelight? He's a famous person. He seeks celebrity. Of course he is. But this isn't a libel suit. This is privacy, and a lot of times there's a misconception that public figures lose their right to privacy. Now, there's two possible tort remedies that they could go after here. The first would be intrusion, the idea of the news gathering. Now, he was given it, allegedly, by two hospital employees who have been fired, so if they're called into court, they're going to admit that they gave it to him. Okay. That one's closed. Then he obtains something that there is a reasonable expectation of privacy. Also, there's a Florida statute about medical records. So that's two strikes right there. Now, the other claim would be for publication of embarrassing facts, the photograph and the facts surrounding it. Is it a matter of legitimate public concern? That's what the the plaintiff would be Paul, the respondent, the person who's being sued. That's what he's claiming. Well, what do you mean by a matter of legitimate public concern? Is there an expectation of privacy here that your finger or your repaired finger, just because you're a football player, is that something that's people's business? Well, they'd argue, sure, he's famous and so forth. But when it's already protected by statute that someone is in a private medical file is being not only obtained but shown to the world, that's kind of a tricky area there that, well, if I was his lawyer, I would advise let's settle this thing and get it over with. Now, on the other hand, from the ethical point of view, which we teach both media law and ethics, in his statement, he's already admitting that he should have had sensitivity, and that's one where, oops, when you do something like that, be careful what you say because that statement's going to come back to haunt him. So if I was his attorney, which I am not licensed to practice law in the state of New York, settle this and get it over with, because there is absolutely no legitimate public concern in showing someone's repaired finger when there is a legitimate expectation of privacy. Now, the other element is how does the public react? Highly offensive to the reasonable person, HORP as we call it, or is an outrage to community decency. Now, there's some folks who would say, yeah, I want to see his finger, man. There's other people that say, that's terrible.
Everything we see on the Kardashians and everything else, though, I can't imagine this being too indecent for public consumption.
Right, but is Jason Pierre-Paul have a reality show? Does he bring people into his homes and have a camera in the bedroom and the kitchen and the bathroom and everything else? No. This is something where it was an operating room. He has a reasonable expectation of privacy. There's a Florida statute covering it. Two individuals have already been canned and, I guess, admit that they released this photo to him when they should not have. So the intrusion claim and the publication claim. The publication claim, is it highly offensive to the reasonable person? Is it an outrage to community decency? Is it a matter of legitimate public concern as he claims it is?
Okay, let's take this aspect of it. Reporters are under pressure now with Twitter and everything else to get the story. Could Adam Shefter have gotten the picture, gotten the image, and maybe have the hospital's name on top with Jason Pierre-Paul and blocked out the image and or any of the report and been okay in this matter?
Oh, well, then somebody
That's being creative now.
Oh, yes, and then somebody comes along with the original and says, oops, you took something out there. So with this, too, you mentioned this deadline pressure and this pressure to be famous and to
get the
be
story.
That's
what they want.
Get it on the air.
Get it and get it on the air.
Ethics and law kind of go to the side, and then afterwards it's like, oops, I guess I shouldn't have done that.
If JPP is successful in this lawsuit, does this open up any possibility for damages, or does the public figure fact come into play here?
Well, that would be in libel. There would be the consequence. Has there been harm to his reputation? And with publication of embarrassing facts, it would be more like, oh, I was upset, the emotional harm, and so forth. It wouldn't be so much reputational damages.
Okay, he's Jack Breslin, professor of media law here at Iona College. I'm Mike DeMurgis.